Every day in the USA, people find themselves in court.
We are hearing case 25 CR 1297, State of Ohio versus Currency Fitzgerald. Present in court is the defendant, who's accompanied by his attorney, Mr. Corey Hinton. We are here today for a change of plea hearing. It is the state's understanding that the defendant is prepared to withdraw his previously entered plea of not guilty and enter a plea of guilty to count 1, which would be amended to include both victims, and that is for aggravated robbery, a felony of the first degree, with the attached forfeiture specification as well as the 3-year firearm specification. Count 4, having weapons while under disability, a felony of the 3rd degree, and count 5, tampering with evidence, a felony of the 3rd degree. The state would move to dismiss the remaining counts of the indictment at the time of sentencing, and at this time there is no agreement with regard to sentencing. Thank you, Your Honor.
Thank you. All right, Mr. Hinton, does that all sound accurate?
Yes, Your Honor.
Mr. Fitzgerald, were you able to hear what the prosecutor just had to say regarding what she believes your intentions are here at this time?
Yes, sir.
She indicated to the court she believes it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to amended count 1, which would include both victims from count 2 as well, but it'll only be one count.
Yes, sir.
The firearm specification included in that count, and you'd also be pleading guilty to count 4, weapons under disability, and count 5, tampering with evidence. All other counts would be dismissed. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all these issues, I'm going to ask you a series of questions. Excuse me. Now, if at any point when I'm asking you any of these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right, let's get started then. How old are you, sir?
17.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
No, sir.
You're not a U.S. citizen?
Yes, sir.
So you're a U.S. citizen.
Yes, sir.
Now, prior to coming to court here today, have you had any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No, sir.
Not even prescribed medication? Nothing?
No, sir. I got melatonin, but we waiting for it to come back in.
So you haven't had that in the last couple of days?
No, sir.
So nothing then?
No, sir.
Now, you would have received a copy, you should have received a copy of the indictment in this case sometime probably back in September of this year. That's the document that sets forth all the charges you're accused of committing. You remember getting that at some point?
Yes, sir.
And at some point, did you have the chance to look that over?
Yes, sir.
Now, in that indictment, you are charged with 8 charges, 8 counts. You're pleading guilty to 3 of those today, so I'm going to go over those charges with you. If you have any questions, make sure you ask.
Yes, sir.
But in count 1, as amended, what's alleged here is on or about July 29, 2025 in Willoughby Lake County, Ohio, that you did in attempting or committing a theft offense, or in fleeing immediately after you attempted or committed the offense, that you had a deadly weapon on or about your person or under your control, that being a firearm, and you displayed it, brandished it, indicated you possessed it, or used it. That conduct constitutes the offense of aggravated robbery. It's a felony of the first degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, sir.
Any questions for me about it?
No, sir.
The charge also carries with it a firearm specification that alleges during the commission of the offense you had a firearm on or about your person or under your control while you committed the offense, and you displayed the firearm, brandished the firearm, indicated you possessed the firearm, or used the firearm to facilitate the offense. Any questions about that?
No, sir.
Now, the next firearm specification is being dismissed, but there's also a forfeiture specification which alleges during the commission of the offense you possessed or had in your possession a Glock 19 9mm firearm, magazines, and ammunition, which were used as instrumentalities. Instrumentalities are property that are used to commit an offense or to facilitate an offense.
Yes, sir.
And that's what it's alleged, that this firearm, the magazine, and ammunitions were possessed by you for. And the whole purpose of this is that you forfeit any ownership interest you have in that property. You understand that?
Yes, sir.
Any questions about that?
No, sir.
Now, the next count you're pleading guilty to is count 4, and what's alleged here and what you're admitting to is on or about July 29, 2025 in Willoughby Lake County, Ohio, that you, not having been relieved from disability in their operation of law or through legal process, knowingly acquired, had, carried, or used a firearm, and that you were under indictment for, or previously been convicted of, or adjudicated a delinquent child for the commission of an offense that, if committed by an adult, would have been a felony offense of violence, that being aggravated robbery, a felony of the first degree in Cuyahoga County Juvenile Court. That conduct constitutes of having weapons while under disability. It's a felony of the third degree. Do you understand what you're charged with and pleading guilty to in count 4?
Yes, sir.
Any questions about that?
No, sir.
Now, in count 5, what's alleged here and what you're admitting to is on or about July 29, 2025 in Maple Heights, Cuyahoga County, Ohio, as a part of a continuing course of conduct with offenses committed in different jurisdictions in which one or more of the offenses or an element of any one or more of the offenses occurred in Lake County, Ohio, that you, knowing an official proceeding or investigation was in progress, was about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with purpose to impair its value or availability as evidence in the proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the third degree. Do you understand what you're charged with and pleading guilty to in count 5?
Yes, sir.
Any questions about that?
No, sir.
Now, there are 5 other counts of this indictment that are all being dismissed. Is that your understanding?
Yes, sir.
Any questions about any of those charges?
No, sir.
Well, then, before I can accept your guilty plea to the charges I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have a right to a trial. Now, a trial could be to me as a judge, or I would listen to the evidence and I'd make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. Unanimous means that all of them, all 12, would have to agree together, one way or another, as to each individual charge, whether you're guilty or not guilty. So all 12 would have to say guilty or not guilty as to each charge. You understand that?
Yes, sir.
Including the firearm specification. Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial, the prosecutor here would represent the state of Ohio. She would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges and specifications, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when I talk about this burden of proof, since it's a criminal case we're dealing with, that burden is what we refer to as proof beyond a reasonable doubt. And that's the highest burden we have in our justice system. What it actually means is the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of each of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to do that, or at least to try to do that, if we were going to have a trial, the prosecutor would bring witnesses that come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
You realize you're giving up that right. Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that? Well, do you understand do you understand all these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. You understand them all?
Yes, sir.
Any questions for me?
No, sir.
Do you still want to plead guilty?
Yes, sir.
All right, give me 1 second. Do you understand that guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on a future day, be sentenced. So again, let me repeat that. What pleading guilty and being found guilty means that you're be found guilty to charge and that you will be sentenced as a result, which won't occur today but on a future date. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty in count 1 to a felony of the first degree. This offense is considered what we call qualifying offense. That simply means it's a felony of the first or second degree that was committed after March of I believe it was 2018 or 2019. And what that means is that an indefinite sentence must be imposed by the court if a prison sentence is going to be imposed, which it has to be because of the firearm specification. Indefinite means that there will be a minimum sentence and a maximum sentence imposed. In regards to the minimum sentence, the court will pick a number between 3 and 11, 3, 4, 5, 6, 7, 8, 9, 10, or 11. Whichever period I pick will be the minimum sentence you have to serve. The maximum sentence for that count then is determined by, it's a mathematical formula. You just take half of whatever the minimum is, you add that half to that minimum, and that becomes the maximum. So for example, if I choose 3,
Yes, sir.
half of 3 is 1.5. I'd add the 1.5 to the 3, and your maximum would then be 4.5. So it would be 3 to 4.5 years.
Yes, sir.
Another example, if I pick 6 years as the minimum, half of 6 is 3. I take that 3 and add it to the 6, that's 9. So your maximum will be 9, so it'll be 6 to 9 years.
Mhm.
Again, hypothetically, if I took 11 years as the minimum sentence, which is the most I could take,
Yes, sir.
half of that's 5.5. If I added that 5.5 to the 11, that would become 16.5. So your sentence would be 11 to 16.5 years. Do you understand that?
Yes, sir.
Any questions as to how that works?
No, sir.
So for that particular offense, you face a maximum sentence of a minimum of 11 years, maximum of 16.5 years. Do you understand that?
Yes, sir.
Now this charge also carries with it a firearm specification, which requires the court to impose a mandatory prison sentence of 3 years, which must be served prior to and before you serve any other part of your sentence. Do you understand that?
Yes, sir.
So when I use the term consecutive, that means separate. You serve each term separately. You understand that?
Yes, sir.
Now, in regards to count 4 and count 5, the weapons under disability and tampering with evidence are both felonies of the third degree. Each of those are punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, which is 3 years, or increments in between of either 12, 18, 24, or 30. So I'd select one of those numbers for each count. They can be the same, they can be different. That'd be the number of months you have to serve in prison for that particular count. Do you understand that?
Yes, sir.
Now, since there's 3 separate charges here, along with the firearm specification, as a judge, I do have the discretion to run the prison terms on the particular offenses concurrent or consecutive. As I said, the firearm specification has to be consecutive. It has to be served first before you serve any other part of any sentence. You understand that?
Yes, sir.
Now, in regards to the other offenses, I can run those prison terms concurrent or consecutive. Concurrent means together at the same time. You serve whatever the prison terms are at the same time. Consecutive, again, means one after the other.
Yes,
So
sir.
you'd serve, if I ordered them all consecutive, you'd serve the prison term for the firearm specification, then whatever I ordered for the weapons of disability, the tampering with evidence, and then you'd serve the indefinite sentence, whatever that is. You understand the difference there?
Yes, sir.
Any questions about that?
No, sir.
So I'm required to make sure you understand the maximum sentence you face by pleading guilty. And if I gave you the maximum sentence for each particular count that I just reviewed with you, along with the firearm specification, and I ran everything consecutive, you're looking at an indefinite prison term of a minimum of 20 years with a maximum of 25 and a half years. That'd be the maximum sentence you face, 20 to 20 and a half years. 20 to 25 and a half years. You understand that?
Yes, sir.
Now, do you have any other charges pending against you right now?
Your Honor, he does. There's a case in Cuyahoga Juvenile Court that resulted from the search warrant that was executed in connection with this case. I know he, through his mother, has been in touch with the court or prosecutor in that regard. There's another pending case from Kent as well. So those 2 cases are pending, and he may be on.
And the Kent is in Portage County, is that Portage?
It is.
That's in juvenile court also?
It is.
Your Honor, the Kent case was actually transferred to Cuyahoga County as well.
Correct.
Okay. But Cuyahoga Juvenile Court?
Cuyahoga County Juvenile Court, yes.
Are they attempting to bind any of those over to adult common pleas court?
I don't know the status of those.
I know he had a prior adjudication in Cuyahoga Juvenile Court, but he doesn't believe he's on probation for that.
Or any type of parole or supervision or anything?
No, sir.
The reason I ask about other offenses, I don't think it's going to be applicable here, but if you get sentenced to prison on another case before you come back here for your sentencing in this case, I could run a prison sentence in this case concurrent or consecutive to that.
Yes, sir.
But I can only do that if it's already been imposed. If it hasn't been imposed yet, I can't order like my sentence be consecutive to some possible future unknown sentence that may happen. I can't do that. It's
Yes,
already
sir.
got to be imposed. You understand that?
Yes, sir.
Now, if I were to sentence you to prison and you ultimately got convicted of other charges in adult court, that judge can run them consecutive to my sentence. But I don't have any say or any authority to do that
Yes, sir.
ahead of time. You understand that?
Yes, sir.
Okay. In this case, upon your release from prison, you would be placed on post-release control, which is sometimes referred to as parole, or PRC. It's a period of supervision you would be on after you serve whatever the prison sentence is. And in this particular case, it's mandatory for at least 2 years, and it could be up to 5 years. It's up for the parole authority to decide exactly how long, but it would be at least 2 years up to a maximum of 5 years. Do you understand that?
Yes, sir.
And if you are on post-release control and you violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, going back to the indefinite sentence for count 1, the aggravated robbery charge, I explained there's a minimum sentence and a maximum sentence. Remember that?
Yes, sir.
In regards to that, there is a presumption that you will be released after you have completed the minimum sentence for that particular count. Now you have to do the firearm specification first, and if there's any consecutive time, that would all have to be done first. But then once you start serving the indefinite sentence, there's a presumption that you would be released after you serve whatever I ordered to be the minimum sentence for that count. You understand that?
Yes, sir.
And what that means is that you would have to be released from prison unless prison officials schedule a hearing because they believe that you shouldn't be released yet, that while you have been in prison, you haven't followed the rules, you're not sufficiently rehabilitated, you remain a threat to the community or society. If they believe that and have a hearing and make that ultimate determination, then you won't be released at the minimum sentence. They'll keep you in prison. They'll pick a new date that it is that you're to be released.
Yes, sir.
And you have to be, there's a presumption you'd be released on that new date unless, again, you continue to misbehave or continue to be a threat or not be rehabilitated. And if at a hearing that was established again, they can keep you in again longer. You understand that?
Yes, sir.
Under no circumstances, however, can you be kept in beyond the maximum sentence for that particular count. So whatever that maximum sentence is for that count, you'd have to be released. Even if you misbehaved every day you were there, they'd have to release you after you serve the maximum sentence. You understand that?
Yes, sir.
Now, you would also have the right, since this is not a mandatory sentence, the firearm specification is mandatory, but once you've served that, you will have the ability to earn what is called good time credit based on good behavior.
Yes, sir.
It's not automatic, it's not guaranteed, but you will have the ability to earn that. And there's a presumption that if you do earn it, that you will be awarded that time. The only way that wouldn't happen, the prison officials will be required to notify the sentencing court, me or whoever's sitting in the seat at that time,
Yes, sir.
that you've earned this credit, and then the judge can disapprove that if the judge wanted to do that. If the judge doesn't do anything, it gets approved automatically. If the judge wants to disapprove it, then he has to schedule a hearing and bring you back for that hearing and have a hearing to determine whether it should be approved or not. You understand that?
Yes, sir.
Now, aside from the prison term I just mentioned, there's other sanctions that could be ordered. You could be fined. The aggravated robbery charge carries with it a possible fine of up to $20,000. The other two counts carry possible fines of up to $10,000. So altogether, if I find you on each count, it's up to possibly $40,000 in fines. You could be ordered to pay court costs and also ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable in this case. Do you understand that?
Yes, sir.
Also, you will forfeit any right, title, or interest you have in that property, as I mentioned earlier. The firearm, the ammunition, and the magazine will be forfeited in the state of Ohio. Do you understand that?
Yes, sir.
Lastly, the court also can order or will order restitution for any economic loss any victim may have suffered as a result of the criminal conduct involved. Do you understand that?
Yes, sir.
Now, as I mentioned earlier, when I was explaining the prison terms, the firearm specification requires that a mandatory prison term be imposed. That means at the time of sentencing, I will not be able to consider community control sanctions or probation. You have to be sent to prison. You understand that?
Yes, sir.
Now, while you are in prison, after you have served any mandatory prison term, you would be eligible at some point to request what's called judicial release. That is a motion that you would make with the sentencing court requesting to be released from prison early and put on probation. Now, you're only eligible for that when you're serving non-mandatory prison sentence.
Yes, sir.
The only mandatory prison sentence here is 3 years for the firearm specification. So once you start serving any sentence after that, you could start becoming eligible for judicial release. Your eligibility depends on whatever the sentence is, how long the sentence is. Depending on how long it is, will dictate how long you have to wait before you can make that request and become eligible.
Yes, sir.
So the longer your sentence is, the longer you have to wait before you can become eligible. But at some point you would become eligible. Do you understand that?
Yes, sir.
Now, just because you're eligible for judicial release doesn't mean you get it. All that means is that you can request it of the court, file a motion, and the court will consider it. You understand that?
Yes, sir.
Lastly, when we do proceed to the sentencing hearing, you'll have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf, recommend the sentence to the court. The prosecutor is also allowed to recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I don't find that that's the right thing to do. Do you understand that?
Yes, sir.
All right. Will you have any questions at all then regarding the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to talk about this case with your lawyer and have him review the reports with you, discuss the issues, and answer your questions?
Yes, sir.
You've had enough time to talk with him about everything?
Yes, sir.
Are you satisfied with his advice and counsel?
Yes, sir.
Has he or has anyone made any promises to you about what's going to actually happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced by anyone to plead guilty?
No, sir.
Are you entering the guilty plea freely and voluntarily? Is this what you want to do?
Yes, sir.
All right, then, Mr. Fitzgerald, any questions for me at this time regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to talk with your lawyer before we go forward with the actual plea?
No, sir.
Very well, then, at this time, what's going to happen here is the prosecutor here is going to explain for me what she believes the evidence would show at a trial if we did have a trial. I want you to listen to her and what she has to say, because then I'm going to have some questions for you about that, all right?
Yes, sir.
All right, Similine?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on July 29, 2025, at the Willow Park Apartments located in the city of Willoughby, Lake County, Ohio, the defendant, his brother Denaro Logan, Joseph Smith, and a fourth male went to the Willow Park Apartments in response to a Facebook Marketplace ad from Jonathan Hernandez. Jonathan was selling a Cartier Moissanite watch. When the three males arrived, they exited the vehicle, that being the defendant, his brother, Denaro Logan, and Joseph Smith, brandished weapons and robbed Jonathan Hernandez of that Cartier Moissanite watch. They also robbed his brother, Enrique Hernandez, of a firearm that he had on his person, that being a Sig Sauer P365XL 9mm, serial number 66B632569. They did so without the consent of Jonathan or Enrique Hernandez. The three males got back into the vehicle and left. A BOLO was issued for the vehicle. The vehicle was located by the Bedford Police Department. The vehicle fled when Bedford attempted to stop the vehicle. When the vehicle was ultimately stopped in the city of Maple Heights, the defendant did flee from the vehicle. In the area where he fled, police located a loaded Glock 19 Gen 4 model 9mm firearm with magazine and ammunition. That serial number is BMBG231. And a little further away, a neighbor had also located a red Cartier Moissanite watch box in their yard. The defendant does have a prior adjudication for a juvenile adjudication in Cuyahoga County, case number DL23107779, dated November 2nd, 2023, and that was for aggravated robbery, a felony of the first degree with a 1-year firearm specification, and grand theft, a felony of the fourth degree. Thank you, Your Honor.
Thank you. So, Mr. Fitzgerald, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we did go forward with the trial?
Yes, sir.
What, if anything, do you have to say about those facts as she just presented them? Are they true? Did you do what she said?
Yes, sir.
Very well, then, regarding count 1 as amended, charging with aggravated robbery involving both victims, a felony of the first degree, what is your plea to that?
Guilty.
As for the firearm specification, the 3-year firearm specification, what is your plea to that?
Guilty.
As for the forfeiture specification, what is your plea to that?
Guilty.
As to count 4, charging with having weapons under disability, a felony of the 3rd degree, what is your plea to that count?
Guilty.
And lastly, as to count 5, charging with tampering with evidence, a felony of the 3rd degree, what is your plea to that count?
Guilty.
All right, I have in my possession here a document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document and what it says, and that you sign it here in open court. Now, my understanding is that before I walked out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sir.
Mr. Hinton, is that accurate? Did you review this with Mr. Fitzgerald, read it over with him, answer all his questions?
Yes, Your Honor. Prior to today, we did sit down and go over it. I read the entire document to him. I provided him with a copy of it, and then I was able to touch base with him on it again this morning in court.
Did he indicate an understanding of the contents of that document too when you went over it with him?
Yes.
Is that correct, Mr. Fitzgerald?
Yes, sir.
Do you understand what this document says?
Yes, sir.
Do you have any questions for me about it?
No, sir.
Now, it does appear that you signed it a couple times. Did you in fact sign it?
Yes, sir.
And you witnessed that, Mr. Hinton?
Yes.
And Ms. Himmeline?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. The court further finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of amended count 1, aggravated robbery, a felony of the first degree in violation of 2911.01A1, along with the 3-year firearm specification, that's the first specification, and the forfeiture specification. I also find the defendant guilty of count 4, having weapons while under disability, a felony of the 3rd degree in violation of 2923.13A2, and count 5, tampering with evidence, a felony of the 3rd degree in violation of 2921.12A1. The remaining counts and specifications of the indictment will get dismissed at sentencing. Sentencing will be deferred. I'm going to order a pre-sentence report and investigation and victim impact statements. I think that covers everything. Is there anything else for the record, Ms. Himmeline?
Just with regard to housing, Your Honor.
Okay, go ahead.
The state would make an oral motion to transfer the defendant to Lake County Jail. So he's presently being detained at the Lake County Juvenile Detention Facility upon entering a guilty plea under 2152.02. The defendant is no longer considered a child under the eyes of the law, and the state is asking that he be transferred over to the Lake County Jail to await sentencing.
Is that mandatory or required, or is that discretionary?
It's discretionary. So 2152.02C7 states that upon either conviction or pleading guilty to a felony in adult court, the juvenile loses that status, and that's also reiterated in 2152.02C5, but there is no requirement that the court.
Is that, the juvenile court judge doesn't have that
Correct. So
authority.
the juvenile, when a case is bound over, the juvenile court does retain jurisdiction to determine where the defendant would be
Remember we
housed.
discussed this at the pretrial.
Right. And so now, upon entering the plea of guilty, that divests the juvenile court of that remaining jurisdiction and puts that now within the jurisdiction of this
So
court.
I wanted to make sure I wasn't stepping on anyone's toes or anything.
Correct. 2152.02C5 specifically states that upon a plea of guilty, quote, the defendant shall be deemed after conviction, plea, or invocation not to be a child in any case in which a complaint is filed against the person.
Okay. Mr. Hidden, did you want to be heard in this?
Thank you, Your Honor. As to this issue, and speaking with Mr. Fitzgerald, he would like to remain at the Juvenile Detention Center. He's on level 4, which my understanding is a good thing. It means he's behaving there. I know initially when we were addressing this case, at one of the first hearings, there was an indication that when he first got into the detention center, that wasn't necessarily the case, but I haven't heard anything that he's misbehaving over there. I believe he's following all the rules, not losing points. Even though he was bound over as an adult, he is 17. I know at the detention center it's a bit easier for him to communicate and have contact with his mother. I know she just went over and spoke with him yesterday. I don't know if it was in person or on the phone, but spoke with them about the change of plea process and that sort of thing. I know that he's been there for a while. He's comfortable over there. I think that it would make sense, and it would be our desire to keep him in the detention center until he's sentenced. He knows that he's going to be sentenced to prison, but my understanding is if he goes over to the jail that he's isolated from the adults, and I believe he basically sits in a room with a TV.
I'm sorry.
I think that when he's over at the detention center, they're doing a lot of things as far as going to school during the day and things of that nature. So I think that would be better than him just sitting in a room by himself. We certainly respect the decision of the court, but that is our thoughts on it, Your Honor. Thank you.
Well, in this court's view, he should have been in the jail since this happened. He's being treated as an adult. He's going to be treated as an adult, so he's going to be housed in the Lake County Jail. Anything else for the record?
No, Your Honor. Thank you.
Go ahead.
Your Honor, as far as the pre-sentence report, I know that probation's not on the table, but if the court during the pre-sentence report would order a mental health evaluation, that may be useful to the court in trying to gather facts regarding the defendant for purposes of the sentence.
I'm not necessarily opposed to that, but won't I have that? Isn't there a lengthy evaluation that was done in juvenile court or not? Or was this a mandatory
This
evaluation?
is a mandatory, so there was no amenability.
All right, my fault. Then yeah, I'll order a psychological evaluation.
Thank you, Your Honor.
Yeah, the only reason I didn't was I was thinking that there was one from juvenile, which I'll have the ability to read, but if there wasn't, we'll do it.
Okay, thank you,
Got
Your
that,
Honor.
Stan? All right.